Welcome back to Senate Education. It's May 6th at 2:25 in the afternoon. Uh, Thank you, Mr. Desmarais. We have before us a document that you've created, Use of Public Tuition for Private Religious Schools, Legal Principles and Analysis, that we look forward to walking through with you. And senators also know that we do need to stop because of scheduling. Michelle Childs is available at 3, so we will shift gears there and go to H183 at that point. If we need Mr. Desmarais back after that, if it works for you, Jim, we'll have you back.
Of course, yeah.
Okay, great. All right, the floor is yours. Thank you.
Okay, so for the record, Jim Desmarais, Lett's counsel. I don't usually read my testimony, but I'm going to read this one because I'm trying to, this area, as we know, is very complex. I'm trying to boil it down to as simple principles as I can. So let me read through it. And obviously, if you have questions as I go through it, please stop me and ask. So this testimony goes through 2 questions. First, are Vermont school districts required to pay tuition to private religious schools? And the second question is, can Vermont require religious schools to comply with the anti-discrimination laws that apply to public schools as a condition to receiving public tuition? Those are the 2 questions this testimony addresses. So in the first question, as to whether school districts are required to pay public tuition to private religious schools, Vermont statutes authorize Vermont school districts to pay public tuition to approved independent schools, which are schools that meet standards established by the State Board of Education. These schools may include both secular schools and religious schools. For example, Thetford Academy is a secular school, and Rice Memorial High School is a religious school, and both are approved independent schools. Because the public benefit is available to secular schools, it cannot be denied to religious schools based solely on their religious status. To do so violates the free exercise of religion clause of the U.S. Constitution. However, the Vermont Constitution requires that if public tuition is paid to religious schools, the schools must establish safeguards to ensure that the public funds are not used for religious instruction. The nature of these safeguards has not been defined in statute, and school districts have not received state guidance on this question, except for recent AOE guidance that was then withdrawn. In the absence of guidance,
all right, if I may, I'd like to pause there and just, would you tell us why the guidance was withdrawn?
Yes, so AOE provided guidance about a month or so ago, which basically said to school districts that in order to pay tuition to a private religious school, the school district should get a certification from that school district stating that the public tuition won't be used for religious instruction. The AOE, the state board, has been involved in litigation through its administrative process. And part of that process ended up in a settlement with the people bringing the lawsuit. And they thought that the guidance they issued was interfering with their ability to settle that case. I can't describe exactly how, but they withdrew that guidance, not because it was bad guidance, but because it was interfering with semi-judicial process that they were involved with.
So is it possible that they were told through this negotiation, if you will, or the settlement, that they had to remove it?
I don't think they were told they had to. It's really for AOE to testify about more than me, because I wasn't that closely involved.
So
But
is it appropriate? I mean, does it strike you as, it strikes me as a little bit concerning that they would withdraw that guidance.
I'm not sure if it's inappropriate. I mean, there's balancing two things, obviously, and trying to resolve a case against the a case against the school district. So they're trying to be helpful in resolving that dispute.
So they, in some ways, could you say that they changed their policy to settle a suit?
It was due guidance.
They changed guidance to settle suit. Senator Hooker.
So can you clarify for me what's been withdrawn? Is it the requirement to have certification?
Yeah, the guidance was, it was not a requirement, it was non-binding because the AOE doesn't have authority over school districts. School districts are the ones to make the determination as to whether or not it is appropriate to pay tuition to independent schools. So that resides in the school districts.
Mhm.
The guidance from the agency was non-binding, and it suggested that the path forward was to get a certification, as we'll come on to in this testimony.
Okay.
Thank you.
Yeah. Okay. Okay. So in the absence of guidance, school districts have been denying requests from parents to pay public tuition to religious schools based on their religious status. The religious schools have challenged the denial of public funding in court and through the State Board of Education's administrative process. And because these denials were based on their religious status, the rulings in these cases are in favor of these religious schools, or they've been settled out of court with the same result. A draft bill being considered by you would prohibit a school district from paying public tuition to an approved independent school, whether secular or religious, unless it receives a certification from that school that states that none of the tuition for which payment is requested has or will be used to support religious instruction or worship or the propagation of religious views.
So if I may, we would basically be returning what the guidance document had in it.
Correct.
Thank you.
Correct. Yeah.
Senator Lyon.
This might actually take us a step backwards, and I don't need to
Okay.
answer it right now, but when a school is declared an independent school by the state, is the application process? How does that happen? And then is there ongoing renewal or review and renewal for schools that are independent schools?
Yes. So to apply to be an approved independent school, there is a set of board rules on the application process and the requirements they have to meet. And the approval is for a period of time. I think it might be 5 years, or I'm not sure how long it is. There's different paths, but it is subject to review and reapproval.
So then a follow-up question for that is, if a school does not wish to be an independent school, but continue to educate children, can they do that in this state? And will the kids then meet academic requirements?
So we're talking about approved independent schools. So
Okay.
there are two categories of independent schools in Vermont. There's approved, which have to meet these requirements the state board has established. And if you're approved, then you are eligible to receive public tuition. And then separately, there is recognized independent schools. Recognized independent schools basically count in terms of truancy. So if you send your child to a recognized school, your child counts as being in school, but that school is not eligible to receive public tuition.
Senator
So it's
Hooker.
all about public tuition.
I'm sorry?
No, it was just a comment. It's all about public tuition.
Yeah, so, well, two reasons to get approved. One is for public tuition, and one is for the status of being approved. So some schools, and particularly so far, religious schools have been approved, even though they haven't been receiving public tuition, because the approval gives them a status that's recognized by parents.
Senator Hooker.
Okay.
And Jim, do all approved schools have to comply with the laws, have to abide by the laws that public schools have to abide by?
No.
In order to get tuition?
No. There are requirements for approved independent schools, like they have to have harassment, anti-bullying policies. They have to offer certain courses. There are certain requirements for them, but they're not equivalent to a public school.
Okay, and so then that begs the question, do they have to comply with anti-discrimination laws? And is that what we're getting
We'll
at?
get into that. Yeah.
Okay, thanks.
Senator Lyons.
Yeah, one, uh-oh. Oh, do recognized schools also go through, do they get recognition every 5 years? Or is that only for the approved?
There used to be a process for that, but looking at the most recent set of state board rules, I don't see that process. So I'm not sure what's
Huh.
happened to it. Those rules are going to be updated, I think, soon by the state board.
Okay, okay, thank you.
You may recall a couple of years ago, the state board overstepped its boundaries by basically adopting rules or trying to, which would impose all the public school requirements on independent schools. And that led to a big issue, obviously, and they withdrew that. But I understand they're coming back to that issue at some point.
Thank you.
That would have to be statutory.
The rules don't have to be statutory.
No, I
Um,
mean the declaration of meeting all the criteria that
Yeah,
public schools meet.
Correct. Yeah, they went beyond their authority, basically. Yeah.
okay.
Yeah. Which is why in H101 you've got the language around the board's powers. Okay, so going on here, so we talked about certification briefly. So just to note that the certification method is a familiar mechanism used by both the federal and state governments in the past with court approval to provide assurance that taxpayer support funds are not used for the purpose of religious instruction or worship. So that process is well grounded in law. This solution is designed to provide school districts guidance to allow them to pay public tuition to religious schools in compliance with the US and Vermont constitutions. So this solution being the certification process. While the US Supreme Court has recently ruled that public tuition cannot be denied to religious schools based solely on their religious status, it left open the question of whether states can restrict the use of public funds to non-religious instruction as required under the Vermont Constitution. Pause there for questions. Is that clear?
If you don't mind, I'd like to just go back up to letter I.
Yep.
When you're talking about guidance, Jim, do we know exactly what schools are looking for? In other words, you said that there's some lawsuits, schools are looking for guidance. Are they, by guidance, are they looking for just a legislative okay to do this? Sort of, or what exactly is the kind of holdup, if that makes sense?
Yeah, I think what the school districts have not had is the decision in this area in Vermont, which is Chittenden Town back in 1987, basically said Vermont, under the Vermont Constitution, public funds can be used for religious schools. However, there has to be safeguards to ensure it's not used for religious instruction. And over 20 years now, districts have had no guidance as to how to apply that.
Okay, so you're talking about, in this case, the certificate, that process.
Correct.
is What these
Exactly
schools
correct.
are looking for. Okay.
Yep. So we're at an interesting point in time because the Supreme Court ruled just last year that public tuition cannot be denied to religious schools based solely on their religious status. But it left open the question of whether states can restrict the use of public funds to non-religious instruction. So what that's saying is, well, it decided that state constitutions that prohibit funding based on status, that you can't do that. Statutes like Vermont, which allow funding but restrict its use, the Supreme Court didn't rule on that. And the justices seem split on that question. So this is an open area, but currently today, the certification we're talking about, I believe would be constitutional, but might be subject to challenge, given where the court is. So I go on to say, therefore, if the bill language on this topic being served by you were to be enacted, it is likely to be challenged in court. The US Supreme Court could use this case, if it was appealed, to establish whether such use restrictions violate the Free Exercise Clause of the US Constitution. It's unclear how the court would rule, as the justices appear divided on that question.
And so just for clarification, we're still talking about if we were to pass, because our draft bill has a number of things in it, but if we were to pass just the certification piece saying that this is, there can be no religious instruction, et cetera, with these public dollars, that in itself could end up in the courts.
It could end up in court. It definitely will end up in court. I've got almost no doubt about that.
Okay.
This is a heavily litigated area, and there are interest groups doing this.
Sure.
How the Supreme Court might rule on that is unclear.
Okay, thank you. Senator Lyons.
I'm good.
Senator Frischlich.
And Jim, I'm assuming you're saying it's likely because it's already been brought up in other states. There's already current challenges to this type of restriction.
Yeah. So the litigation in Vermont is in part being brought by national organizations who are looking for this
Right.
kind of case to bring.
Have they brought that exact case about requiring a certification or requiring that any public money not be used for religious instruction? Has that case already been brought somewhere in the country, like it's already working its way through the system?
Well, so certainly there have been cases based upon discrimination based upon religious status. So that those cases have reached the Supreme Court, they've decided them. So we know that you can't discriminate on that basis. On the use side, I think Maine has a statute like a constitution like Vermont, and there has been litigation in Maine on this question. I'm not sure where it stands. So there's at least, I think, one other case out there currently that's based upon this element.
And is you're telling us that it's likely, but are you saying that just so we know, or because that's a reason not to do it?
Oh, I'm not saying that's the reason not to do it. It's a policy decision. You can always pass laws that may violate the Constitution. That's up to you as a policy matter. But I'm just informing you that this is very likely to lead to litigation, and if it gets as high as the Supreme Court, I'm not sure how it would go.
Senator Chittenden.
I'm not a lawyer, and I'm sure this is going to be a dumb question, but Jim, I hope you'll suffer me. I feel like with my experience in these types of very well litigated, highly litigated issues, the question you ask is sometimes more as important as what the answer is. And I'm seeing your question too that says, can Vermont require religious schools to comply with the anti-discrimination laws? As I'm also learning in this role, the intent of the legislature is factored in by many constituency groups, and I'm guessing courts as well. Would it not be important in this conversation to go forward to not ask that question, but instead to just state, can we require any school, be it a secular or a religious school, to have any school that receives public dollars to comply with the anti-discrimination laws? Or is that really a moot point that would just be litigated regardless of how we approach this and how we frame the question that we're trying to answer?
Yeah, so we're about to get to that momentarily, but the broad, I'm focusing this testimony on the religious schools, but if you do the anti-discrimination piece, I believe you apply both to secular and to religious schools. And to the extent that it takes away the right of secular independent schools to discriminate, then it's a broader issue, and it has a broader application. I framed it more narrowly, but it does apply more broadly.
Senator Lyons.
So then it would seem that whatever the intent is, so we talk about legislative intent. So if the legislative intent is to ensure student access to state programs like the dual enrollment program, that the use of that we want to ensure secular education that's being paid for with secular dollars, public dollars. I mean, so the intent becomes important. Then if I'm not understanding why we can't look at, and I don't know if there are any, if there have been certification changes in the past, whether in our state or other states, that have not borne legal scrutiny, that they have gone forward without challenge. There must be some of those things that have happened. And then, so I'm trying to figure out how we can pass our bill. But anyway, just, are there cases where states have passed requirements for certification and the use of public dollars that have not been questioned in court? Because we're thinking only about things that are going to be questioned in court. Are there any things that have been done intentionally? Do you understand my question?
I do. I don't have a good answer for your question.
Yeah, I know,
though,
probably
because,
nobody can.
well, because if it's not challenged in
Yeah.
court, you wouldn't necessarily know about that. So I'm looking at the court cases, obviously, and trying to assess those, but have some states passed statutes that have not been questioned? I'm not sure.
Yeah.
Yeah.
Okay.
That's a good question, though.
Let me
Okay,
go on to dual enrollment for a moment to wrap up this portion. So a secondary question that's related to the payment of public tuition to religious schools is the question of student eligibility for dual enrollment. This is because only a student on public tuition under the statute is eligible for dual enrollment. Because religious schools have been denied public tuition based on the stats, their students have also been denied dual enrollment. This has led to further litigation against school districts, and the bill language that you're considering addresses this issue. So I'm going to come over to the second question about the anti-discrimination laws, but I divided it up in two pieces, in part because you could divide your thinking, your bill up in two parts. You could do one bill covering the first piece we talked about, and do a separate bill on the anti-discrimination piece, which I think has a higher likelihood of challenge, actually. So turning to the second question, which is, can Vermont require religious schools to comply with the anti-discrimination laws that apply to public schools as a condition to receiving public tuition. So under the US Constitution, religious schools are exempt from anti-discrimination employment laws for employees in a ministerial role. This permits employment discrimination. The definition of ministerial role is vague, but includes teachers who provide religious instruction. Some more. And to briefly put that in context, this is a very recent case at the Supreme Court where two teachers at a religious school who weren't trained in theology, or they were teachers, taught a class, and part of that included religious instruction. Part of it included walking the students over to a prayer service, and they were viewed as in a ministerial role. And they claimed discrimination based upon age and disability. And those cases were thrown out of court because the schools were protected by this ministerial exception, basically. So they're allowed to discriminate based upon various categories if the employee is in that role. And then going on.
If I may, and that's, again, that's a very broad definition, I think, right? We're talking, I mean, that's part of the situation. It's not as though you might have a master's in divinity, but you might, you know, you're doing kind of roles that a minister may do.
Yeah, however that's defined, it's not well defined. I mean, it could even be someone who's not even teaching, I suppose, who is someone involved in prayer service or something. So,
Yeah, okay.
And then secondly, Vermont's anti-discrimination public accommodations laws, they prohibit discrimination based upon race, creed, color, national origin, marital status, sex orientation, or gender identity in schools if the schools are places of public accommodation. Religious schools are exempt from these laws if they are not places of public accommodation. That is, if the services are not offered to the general public. While determining whether a school offers its services to the general public is a fact-specific analysis, some religious schools do discriminate against students in these protected categories, and therefore presumably do not believe they are places of public accommodation, and therefore believe they are allowed to discriminate in this manner. So what this is saying is that a place open to the general public has to comply. So a public school has to comply with these anti-discrimination laws because they're a public accommodation. But a private school, whether it's secular, to Senator Chittenden's point, or if it's religious, may not be because they are not open necessarily to the general public. And therefore, if they're not open, they can discriminate against these protected classes.
So can I just ask a question here? And this may have nothing to do with what we're talking about, but just the fact that these schools are accepting public funds through tuition, does that not somehow make them public accommodations? Or can they, is the fact that they can deny a student who requests to go there, you know, does that enter into the equation?
No. No.
Okay. So just the fact that they're not open, even, well, what about if people are allowed to go to their prayer services?
Well, again, that's why I said it's a very fact-specific determination. So if you're looking at this, you have to look on a case-by-case basis. My broader point is that schools do, I think, view themselves as not a place of public accommodation, and they do discriminate, in fact.
All right.
Yep.
Thank you.
So public schools are subject to these requirements.
Senator Lyon.
Just quickly, has there ever been a test about the religious dogma that's used within the school as it relates to the discriminatory practices in the school? I mean, has the religious institution ever been tested against its tenets of belief?
No, I think, well, I can't say no definitively, but this is the kind of the big issue here from the Supreme Court standpoint, which is free exercise of religion
Right.
means to the court right now, I believe that the state can't go in basically and assess the dogma of the school, basically. It's
Okay.
allowed to exercise its religion as it feels appropriate. That includes, like, for example, a Catholic school wouldn't be hiring a female priest, or right. So that's a form of discrimination against women. That's permitted. So you have these exceptions basically to accommodate the views of these schools, but in terms of testing in court, the courts are very hesitant to go in and go question dogma, if you will.
Okay, I guess looking at it the other way, excluding that, not looking at the Catholic Church per se, but any another perhaps Christian school that rejects is homophobic in some way with respect to their teachers, but they preach inclusion.
I don't think the
We
courts will get
can't-
involved in that question. I
Courts
mean,
won't get involved in that.
I don't think so. I'm not the expert in this topic, but
Okay.
my understanding
Yeah.
is just reading some court cases, the courts are very hesitant to go there.
Yeah,
Um,
I'm sure. Thank you.
Senator Persler.
And Jim, it seems like, so obviously there's a limit to that religion clause because, we've banned polygamy, and the argument is made, well, my religion allows polygamy, so you have to allow me to practice polygamy, but we know it doesn't, so you can't practice polygamy. So why does that not pertain here? It's just as where the court has decided to draw the line, or is there something, it's because specifically we're around funding these independent schools?
I think Yeah, I think it's a contextual question. So I believe polygamy is a criminal offense, I believe. We're talking now about access to federal funds or state funds as a state benefit. So I think the context is different enough here that analogy doesn't quite hold up in this context. So I'm almost through. If religious schools were required to follow the anti-discrimination laws that apply to public schools in order to receive public tuition, they would be required to give up their free exercise of religious constitutional rights to, in fact, discriminate against employees and students. And in 2017, the U.S. Supreme Court stated in essence that a religious organization's right to participate in a public benefit program cannot be conditioned on a requirement for it to disavow its religious character, which is protected. So when we talk about conditioning funding, public funding, based upon having to comply with these anti-discrimination laws, there is court cases that say you can't condition that, at least to the extent that they have to disavow their religious character. So it raises a question, of course. Therefore, requiring religious schools to comply with the anti-discrimination laws that apply to public schools as the condition to receiving public tuition would almost certainly be challenged in court. And given the Supreme Court's focus the last 20 years on finding in favor of religious freedom under the Fair Exercise Clause, there's a reasonably high chance of the court holding, if the case was appealed to it, that this requirement violates that clause. Can't say that with certainty, of course, but we're talking now about the court basically shifting over the last 20 years. We're talking about a conflict between equal protection and free exercise of religion. Two constitutional provisions. Over the last 20 years, I would say free exercise of religion is winning out over the equal protection argument. So I'll conclude there.
Jim, this was incredibly helpful. Terrific summary. Thank you very much. And I think it gives us a number of fronts to consider. And as I mentioned, we'll likely be hearing from the Attorney General's office tomorrow with hopefully some guidance as to how we might move forward, since we still have time and we have a vehicle to move a bill if we decide to do so. Any final questions or comments from Mr. Demery, Senator Chittenden?
Find I get myself in trouble when I think out loud in this role, but one question I do have that, and not, I want to preface this by saying it's nothing I would necessarily endorse, but I'd love to know if this factors into the discussion. Do we only have this discussion before us now because we allow the tuitioning of public dollars in some school districts? And might another path be to just eliminate that? Again, prefacing it to anybody watching this, I'm not saying we should eliminate the ability of school districts to send tuition dollars elsewhere, but is that unique to Vermont in that we have some school districts that don't have schools that allow for tuitioning?
Well, it's not unique to Vermont to for states to provide public tuition to secular and religious schools, right? So that's common. But once you offer that benefit, that public aid to a secular school, you have to offer it on the same basis to a religious school. So if you were going to eliminate tuition altogether, you wouldn't have this issue. But Vermont has a 200-year history of funding using public tuition for private schools.
Thank you.
Senator Lance?
So going back to the certification process, over the past 100 years or so that we have had independent schools and certified independent schools, how many times have we made changes to that certification, if any? I mean, have we? So is there a history of non-intervention, of not changing our certification process or conditions?
When you say certification, do you mean the certification we're talking about now?
I'm
Or
talking about,
who-
we currently certify, we approve.
proof? Okay,
Yep,
yep.
we have approval for that. I guess that's certification. I
Well-
don't know if you call it that.
Okay, I was confused between the certification we're talking about now versus the approved process, but
The
approval,
approved, yeah.
yeah, the approval process has been in place for a while, but I don't know the history of it, so I can't trace for you how it's changed over time.
So if there are conditions associated with the approval process that have changed over time, then there is a history for that. That would give some credence to making change.
But there are definitely conditions upon being approved as an independent school, and that I'm sure that has changed over time. But now you're talking about putting a condition for these schools to receive public funding based upon their agreement to comply with these anti-discrimination laws. That's a kind of a different level, if you will. That condition gets you into this territory of this conflict between.
But if also the culture has changed around in our state, so we have changed, and we accept certain things that we didn't accept in the past. At least, in 100 years ago, we certainly didn't accept. We almost didn't accept a Catholic marrying a Protestant. So there have been cultural shifts over time, and so is there any legal defense for changing our laws because our culture is changing? And obviously there are a lot of examples in our state that point to that.
it's a very broad question.
Yeah,
Senator
it is.
Lyons.
I'm sorry.
I'm not sure if I
We'll
can answer
take
that.
that to the court, right?
Yeah. I'm looking at this specific context, which has had so much litigation in the last couple of years as it's become a different animal. I will say, I know Michelle's here, but
Yeah.
if you want me to come back after her testimony to walk through the bill, I can do that.
Yeah, if you wouldn't mind coming back. I don't know if we need to go through the bill at this point, but maybe just, as thoroughly, but maybe just a high overview to remind us of the work that's in it. That would be great.
Okay, yeah.
Terrific. Committee, let's shift, if you would, to H183. Michelle was here. Jeannie, would you let Michelle know that we are ready to roll?
Certainly.
Thank you. And senators, you'll see on our website, Michelle's done an incredible job of referencing suggested changes by Senators Lyons, Perchlik, Hooker, and the University of Vermont. And when she arrives, can take us through it. Senator Perchlik?
Is it draft 1.1? I saw that you sent 2 and she said, no, use this one. Is that 1.1?
I'm looking at 1.1.
Yeah, that's what's on our website, but I remember she sent out 2 emails. I just wanted to make sure we had the right one.
Okay.
I'll look.
I know she's I think she's available until 3:30.
Can I just say how great that was to go through
Yeah,
again?
it was great.
I mean, it was terrific. Thank you, Jim.
Yeah, thank you.
He
Jim.
disappeared, but
Very good, very
Yeah.
good teacher.
it's really great.
Yeah, very helpful.
Yeah, that's the right version at 8:49 p.m.
Great.
I'm gonna hop off for a few minutes to join at S13.
You bet. Thanks.
I'll come, but just have Jeannie email me when you're ready.
Okay, thanks, Jim. Appreciate it. No word back, Jeannie?
Not yet. And I didn't hear what Jim said, but it sounded like maybe he mentioned my name.
Yeah, we're going to ask you to email Jim when we're ready to have him back.
Okay.
Thanks.
Well, for what it's worth, I like all the changes made by Senator Hooker and Lyons and UV.
I like all your changes too.
Good.
But I like the pink color a lot.
Michelle, welcome back.
Hi, sorry about that. I lost my connection and I thought maybe it was y'all, but I guess it was me.
No problem, no problem. Thanks for being with us and
Sure.
appreciate you taking the time. First of all, thanks. This looks so great in terms of helping us to understand the recommendations, which recommendation was made by which individual. So we'll give you the floor if you want to take us through the suggested changes one at a time. And if somebody wants to say a bit about why they'd like that change, and then I think we can hopefully maybe get to some conclusions by the time you need to leave at 3:30.
Sure.
Great.
And so actually do you think that 3:30 might be a ballpark? Okay, I had to get out of another committee and they want to know when they can have me back. So I just.
Yeah, I mean, I'm thinking, how long do you think?
I don't think this will take long unless there's
Okay.
issues, so.
Okay, we'll go
Okay.
with your estimate on time.
Right. Hey, Jeannie, would you mind just emailing Andrea and letting her know that I can be back in government operations by 4:15?
Sure.
Thank you. I appreciate it. Okay, so all right, so we're taking a look at the draft, and you don't like to share the screen, correct?
We have it right in front of us.
Okay.
Unless that's
So in section 6, and you'll see the first changes were recommended by Senator Lyons, and that discussion around should it be sexual violence, sexual harm indicates kind of a broader scope. And I think when you're talking about this kind of thing, I think that's appropriate. Then subsection A, it's just a technical, so striking out the word including. Then
Senator Lyons, you want to add anything? I think those are great. Appreciate you.
No, Michelle's doing a great job.
Okay,
next is on the membership. And so if you look at down on page 3, Senator Hooker made a suggestion around diversity, and we kind of went back and forth a little bit about how to address the issue of diversity within the council, because you have independent appointing authorities. It's not just like one body. So looking at the whole picture saying, oh, I need to have a diverse group. And then some of this, so there is some required diversity in there with regard to there is the LGBTQ community represented in some appointments, as well as racial justice organization. But we thought just adding this subdivision 2 says to ensure a council that is reflective of Vermont's college campuses, appointing authorities shall consider diversity when making appointments to the council. Sometimes they're not going to have a lot of options. It's going to be who is doing that particular job, like with a Title IX coordinator, that is the Title IX coordinator, or perhaps with certain folks in some of the appointments, may not be able to have a lot of options to choose from. So we just kind of thought there, it at least introduces the concept. Okay, to keep moving on?
please. I'm not seeing any opposition.
Sure. So subsection C is the duties, and I've reworked this because there were a few folks who had comments on this. So you see the first one in subdivision C1, and Senator Lyons had suggested that she wanted the council to review the recommendations from the report from the task force and develop prevention solutions to sexual harm based on those recommendations. That also addresses a couple issues that Senator Perchlik had raised about specifically things that were in that report that were not part of this new council's role necessarily. And so they're going to start with basically looking at some of those and kind of trying to come up with some specific solutions about how to address that. And remember, they're required to do reporting back to you. So if it requires any legislative action, then they would let you know.
Okay.
I
Yeah.
included that because of Senator Perchlik's comments during committee. So.
Great, thank you.
So the next one is subdivision 4. And so this was the suggestion by that came from Wendy from UVM, speaking that language, and you seem to be fine with that. I really don't, to me, it doesn't change it substantively, but it makes a difference to them. So I did include that. That's the subdivision for new language. Top of page 4 and subdivision 5, Senator Lyons had asked to include identify campus-wide activities, publications, and services that promote a campus culture of respect to support in the prevention of sexual violence.
Great point.
And then lastly, Senator Perchlik had asked, and this is a specific recommendation from the task force, but it's unique in the sense that it's looking at asking them to come back this year so that you can take action during the session of 2022 on this particular issue, which would be recommending statutory protections that ensure so that survivors of sexual harm aren't punished or there's no retaliation for reporting. So in the instance of, if there was the circumstance where they were at a party and there was underage drinking and it's kind of, when you think about, you just passed that limited liability bill last week or the week before with regard to sex work, of saying, we want people to come forward, we want people to report, we don't want them not to do that for fear of getting tagged for an alcohol or a drug offense. And so it's the same concept there. And I pulled this one out, even though you have that language in subdivision 1 where they're to look at those, but this kind of puts it up to the top to say we want to work on this particular issue soon.
Thank you for that. Senator Perchlik.
Yeah, Ms. Childs had brought up the issue, which I don't know if, I'm sure you did it somewhere else, about November 1st, not giving them enough time to actually come up with the recommendation, because if they don't meet till September, so that one thing, and then, but maybe that's below. And
That's
then
in
I just want-
subsection F.
Okay, and the other thing is, when they bring the protections to the General Assembly, what does that mean? Do they just, I just wondered if we should be more specific, like to the Judiciary Committee or something, because I don't know what it means to recommend something to the General Assembly. Could you just tell one person about it, or?
You know, I think people have different views on that. The way that we have the system that it works now is that regardless of who they're reporting to, if it's a certain committee or General Assembly as a whole, there's a process on our website for the way that people submit legislative reports. And then they all go up on the website. And we've got an internal process of trying to keep track of the reports that are due to the committees of jurisdiction, essentially, kind of so that we know to be looking out for them. So I think my preference is, rather than to say this committee and that committee and whatever, because when you're asking outside entities to do that, sometimes they get kind of confused with that or the process for it. And I find that they're a lot clearer if they just know, go to the website, upload it like you're supposed to, and the instructions there, and it's done, and we'll take care of it there. And usually organizations that are doing these reports, they kind of tend to do a little check-in with us about it, because especially if they're looking for some legislation. And as I talked to Senator Perchlik about it, is I put the November 1st date there because it's the second year of the biennium. You have earlier drafting deadlines, especially in the Senate. So you want to make sure that you get that information you need and then work with me on, or whoever it is, to kind of develop the legislation if you want to move forward next January. And related to that, the House version had a kind of a deadline of September 1st for convening the first meeting. But if you want them to have a recommendation to you by November 1st, then they're likely only to get that first initial meeting in. Remember, they're limited to 4 meetings a year. So I thought that so I moved it up to July 15th to have the first meeting. And then that way, hopefully they could get a meeting in the summer and a meeting in the fall, and be able to work on those recommendations for subdivision 6.
Does the bill take effect upon passage?
I'm sorry?
I'm okay. Was that to me?
Yeah.
Sorry. I'm fine with that. That's fine. I just wondered about, is the bill take effect upon passage, or is it July 1st or?
July 1st. And
If it's July 1st.
You can make this section effective on passage if you want, but in general, they know this is there and coming, so it doesn't really make a difference. But I can change the effective date if you'd like.
Just if we're going to have a meet on 15th and they have to appoint people and all that, then if we give them a little extra time by say this section is upon passage, it's a small help. Maybe.
I think
Sure.
that's a great idea. Senator Hooker.
I don't know if this was a typo or if it's meant to be, but on line 10 of page 4, it says on or before December 2022. Was there supposed to be a day in there, or is it just?
Right. And and I noticed that, and I honestly don't recall at this point in the session. So you can pick a date if you'd like, and I can add that. I haven't had this because it's all colored and strike throughs and stuff. I obviously haven't had this edited yet. So if you approve it, I'll take everything out, get a clean copy, and get that to you, since you don't have jurisdiction and you're just kind of approving it in concept, and then I can send it to everyone once we've got a clean copy for you to present to judiciary, or for me to present to judiciary, whatever is because the judiciary does have it up for a vote at 8:30 tomorrow morning.
Well,
And just so folks know, Dick, they're happy to pass over. I mean, I think we're going to get to a point today where we can send it along to Sears and say, hey, have a look at this and have some discussion. I don't know if they're going to ask us to weigh in again or not, but But to the point, Senator Hooker, you're asking, did you want that December 1st, 2022?
Well, I'm
I mean,
just
you're right. I
wondering.
think if
Yeah,
that's,
we usually have a day.
I think you're absolutely right. So
Well,
we're going to make it December 1st.
That's fine.
Thank you. Senator Lyons.
No, so just two questions. Michelle, you said, when you looked at number 5 on page 4, at the top of page 4, you said to support the prevention, which is what was the second email I sent you, but the copy I'm looking at still has to assist in. So just that's a minor detail.
Okay.
That you said
The
it
copy
right. You
the
said it.
copy. Okay, I sent did you get the second version, the edited version I sent out?
I don't know.
Okay.
Yeah, I'm
I
looking
think
at
you
that.
might be looking, my version has the new language
Okay.
emailed me. You might
Yeah.
be looking at the previous
No.
version. You should be looking at 2.1.
That's the
Oh, I'm
version
looking
that's
at
posted.
1.1.
Oh, no,
Probably
we're
the date I'm going to ask you about, the September 15th date is probably also changed in under F1, the first meeting.
Yes, I sent around
Okay.
11 o'clock. I sent something to you and to G
Okay.
to
Okay.
use the
Michelle.
2.1.
That's the version that's posted is your.
That's not the version that I see posted. I've got 1.1 on mine that's been posted. Jeannie, can you get 2.1 up?
Sorry, I
Yeah,
should have
looks
started
like-
out talking which version.
No, that's okay. Senator Persley?
It just looks, that email from 11 looks like you might have just accidentally attached the wrong version because it looks like that.
The same thing.
Oh, did it really?
I think
All
so.
right. I will send this one again. Sorry about
Okay.
that. So that's all the changes.
Okay, okay.
Um,
Committee, my interest is to basically have this cleaned up, get rid of the colors, send it to Sears tonight within the next hour or so. Say this is where we're at. Have a look. Let us know if you're ready to if you want to send us back to work a little bit more tomorrow, or if you want to have your committee consider it tomorrow morning. Is that where everyone else is at, or I'm looking at generally Senator Hooker, you look concerned. No, okay.
No, I think
Okay.
that's a good plan.
Michelle, would you email me a clean copy and copy Sears and just or send it to him and copy me and just let him know that this is where we're at, have him, ask him to take a look at it and get back to us if he has concerns or questions. And if not, this would be our what we would like them to consider tomorrow morning. Senator
Sure.
Persley.
Would you like me, was your preference, because I can just make these changes very quickly and send you a copy. Would you like me to do that so you can get the concept out there, or do you want me to have it reviewed by the editors before I send it out to everybody, including Senator Sears?
Oh, I just want to send Senator Sears a draft. It does not
Okay.
have to go through editing. I just want him to see the general concepts where we're at. Senator Persley.
I guess it goes without saying, but I remembered that the original kind of charge was two questions. Like one, should we even include this in the bill? And then two, if so, what? I assume we've all just kind of agreed by consensus on the first question, and we moved to the second question of what it should look like.
Well, yesterday
Right.
we did take a little straw poll, as you may recall. We just said, hey, I'm going to tell, this was yesterday, I'm going to reach out to Senator Sears and say, we are definitely going to put something in with some changes. And not having seen any objection yesterday, I went ahead and told him just that we are going to advance something his way.
Okay, I just forgot.
Does that sound, what's that?
I just forgot.
You might have been talking over me at that point. Great. So I think, just getting them some general, so two things at once. I think we send it to him while it goes to editing. And That way we save a little time so that he can have just a quick little look to see if he wants us to consider anything else or if he has any questions. Does that sound all right, Michelle?
That sounds good.
Okay.
All right, I'll send y'all something out in the next 30 minutes.
Okay, great. Thanks so much.
Sure, no problem. Bye-bye.
Bye-bye. Okay, Jeannie, would you ask Jim to come back, and let's just take a 5-minute stretch, 5-minute break, and we'll just have Jim go over the highlights to bring us back